part of the justice system here in Uganda. Now, the guiding principle often cited in law is that justice must not only be done, but it must be seen to be done. When questions arise about a judge's impartiality, one of the key legal mechanisms that protect the integrity of the court process is a recusal, where a judicial officer does step aside from handling a case to avoid any perception of bias or conflict of interest. In other words, in a layman's point of view, it would be that if it's been found that one judicial officer is biased about a case, they'd have to step aside and step off the case handling of that case, and then another officer, judicial officer, would be appointed in that regard. But what exactly does a recusal mean in legal terms, and when does it happen, and what safeguards do exist if a judge declines to step down? To help us unpack this important issue in the administration of justice, I'm joined by Mr. Chintu, Registrar of the Civil Division of the High Court in Kampala. You're most welcome.
Thank you very much.
How are you?
I'm good. How are you?
Very good.
Yeah.
Now, let's start with the definition in terms of the concept of recusal. In the judicial practices, we often hear the term recusal, but from a legal standpoint, what does it mean? How is it defined, and how does it apply?
Thank you, dear viewers. I bring you greetings from the judiciary, from our Chief Justice, Dr. Flavian Jaija. On recusal, under the Constitution of Uganda, Recusal of Judicial Officers Practice Directions 2019, a judicial officer may, on application by any of the parties, all on his or her own motion, recuse himself or herself from any proceedings in which his or her impartiality will reasonably be in question. So if the judicial officer feels that he won't be partial in the matter, that he may be biased because of several reasons, or if the public or the litigants feel that the judicial officer has an interest in the matter, or knew the parties, or is biased, then the judicial officer should actually get out of that case. Recusal basically means you leave the case, because justice should not only be done, but it should be also seen to be done. So it's a process that is a legal process where a person makes an application to the judicial officer, or the judicial officer himself gets to recuse himself or herself from the case, to ensure that justice is done at the end of the case.
Okay, so why is it such an important safeguard when it comes to court proceedings?
It is so important as it arises from Article 28 of the Constitution, which guarantees a right to fair hearing. The court has to ensure that the parties before them, or the accused person, receives a fair hearing, and there should not be anything that imputes bias on the part of the judicial officer. So it is very important on the rights of the accused person, on the rights of the parties before you,
okay,
to ensure that the justice is done fairly and equitably.
Okay, let's talk about who should recuse and why. Within the judiciary, who is bound by the principle of recusal, and what are some of the typical circumstances or regular circumstances that may require a judicial officer to step aside from a given case?
No, first of all, when a judicial officer, a judge, a registrar, or a magistrate is allocated a case, after he or she has gone through that case, and he finds that, oh, I might be knowing the parties before me, or I'm privy to the facts, I already know the facts in this matter, so it's like you're already a witness. Why should you proceed with the case? So in case you yourself, you feel that I won't be partial in this matter, then you decide to step aside and let the matter proceed before another judicial officer. Mm-hmm. But even the parties themselves, or the accused person, can make an application to the judge or the registrar or magistrate that I feel, my lord, your worship, you are not the proper person to handle this matter because of reason A, B, C, and D. Or you are known to the other party. I already see you in the company of these lawyers, and the lawyers are representing the other side. So And once they bring that to your attention, it becomes like a small hearing where you listen to the application and then you decide whether to recuse yourself from the matter or you decide to continue with the matter. Yeah.
Okay, so in that very same scenario, Mr. Chintu, if the judge refuses to step down, what happens? If
the judge refuses to step down, the judge has to state his reasons why he or she feels he shouldn't step down. And then the person applying should also state the reasons why he thinks the judge should step down. But the judge or registrar or magistrate has the final say in this matter. Because first of all, we take a judicial oath to administer justice to all matter of people and classes of people without fear, favor, or discrimination. So basically, the judge will continue with the matter, and in case you are not satisfied with the application, the judge has refused to step down, you can appeal, but at the end of the case. You cannot say that I'm appealing against your refusal to step down. That appeal comes as part of your appeal against the whole case. You may even be lucky that you won the case, so you don't need to appeal.
So that is to say that
yes.
The power still entirely lies with the judicial officer?
The power still lies with the judicial officer.
How does that then help those that are seeking justice?
Because justice is a process. There are many safeguards to justice. It is not only you who is there, even the other side has to be heard. So you cannot always decide to choose which judge should handle my case. No, the judges are all equal. They swore to the oath of allegiance and of the judicial oath to do justice to all manner of people. And unless if it is really obvious bias. But if because I'm a lawyer, I was a lawyer before, and so we are all lawyers, so shall we not handle cases because lawyers are appearing before us, or because we sit in the same car? So at times it depends on, it's a case-by-case basis.
Okay, case-by-case
yes.
basis. But at the same time, from an institutional perspective, how does this practice of recusal actually help the strengthening of public confidence to the people in the administration of justice?
That is why when the person fails, the person has to make an application. The judge has to be given an opportunity to reply or answer to that application for recusal and also give his or her reasons. And that is a process that everyone can judge that the reasons he gave, actually, there's nothing wrong. Or if there is something wrong, then those will be your grounds of appeal. The beauty is there is a right of appeal at the end. So the right of appeal also ensures protection of your rights. It is not the finality of the matter. Yeah. Okay,
you have talked about application. What's the process of application?
The process is just a simple letter, which simple letter can be maybe before the matter is heard, the person feeling that the judge so-and-so is going to be biased, he can write a letter to the judge and copied to the registrar of the court and to the parties concerned that he intends to raise an objection to Judge so-and-so or so-and-so from handling the matter. And then the matter is heard in open court. Or if the matter is already in court, then the person can orally raise his hand and say, my lord, your worship, I think you shouldn't continue handling this matter because of the following reasons. You are related to the parties, or you had prior knowledge. I had you discussing this matter on NTV, so you were actually there, so I think you shouldn't continue. And so the judge has to go through the process of also either adjourning or immediately replying to the said, and in case he feels he shouldn't handle, then he forwards back he steps down, or she, and forwards the file back to the registrar, who reallocates it to another judicial officer. But if he doesn't, then he will continue with the matter. Okay,
so there's standard biases, family members, it could be prior involvement in the case or some interests. But what are the other unspoken of, but do existing situations in which there must be recusal consideration to any given case?
Now, in this case, I cannot assume others. It is the public that has all the persons interested. But the rules also provide for several of them. in case the parties are your neighbors. You may find that you are not actually connected, but they're your neighbors. And you want to have good neighborliness. You cannot handle a matter where your neighbors are involved. You may not actually be biased, but the neighbors may feel, why didn't you rule in my favor? Why? Because somehow you always meet with them. You cannot avoid them. So it is better to step aside and let another person handle. After all, there are many other cases that you can handle. And why should you continue with a case where the public is expressly showing that you might be biased? So there are many other files that you can handle. You don't necessarily have to insist on that one. Thank you.
Any other? Because the one of being neighbors is quite interesting.
Okay, in case a family member is representing one of the litigants, you may have, like, I have brothers and sisters who are lawyers, and they appear before your court. Now, I may insist that I saw a judicial oath to administer justice, but somehow I may rule against my brother or my sister, and it may cause also problems. So whether you are right in your ruling, the issue is you made your brother or sister lose the case. So sometimes you get out of the case.
Okay.
Yes.
There's sometimes where litigants may seek recusal simply because they are unhappy with the judge's rulings. How does the judiciary guard against the misuse of recusal applications meant to delay or derail court proceedings? As
in, you're referring to the previous rulings of the judge. I think every case is judged on its own merit. No cases are similar. And you cannot say that previously you ruled against ladies, and we think you are going to be biased against ladies, or you ruled against gentlemen and the like. So that is what I said. You cannot choose who to judge your case. You cannot say that that is called forum shopping. I think Judge so and so will be the right person to handle this case because he previously handled a similar case. No, every judge is competent to handle a matter before, because they were appointed by the president, they have gone through training, they are lawyers, and they are credible in handling any matter.
Okay.
So, yeah.
In terms of impact on case timelines, when a judge recuses themselves from a given case, what happens next procedurally? Does the case start fresh, or does when another judge picks it up, or does it actually continue from where it had reached?
It depends on the level of where the case has moved. If the case is still at its initial stage, the new judge will just continue. If the case has advanced, a new judge may decide either to take on the evidence that has been previously presented or start the case de novo as a new case. That depends on, so recusal can delay, and at times if a judge is the only judge, let me say, the Chief Justice launched the High Court in Lugazi recently, and you find there is only one judge. So when a judge has recused himself, then the principal judge has to appoint another judge to travel to Lugazi High Court to handle the matter. It comes at a very high cost to the judiciary because this new judge is not resident in Lugazi. He or she has to be paid per day for the time she or he is going to spend in Lugazi handling that matter. And you don't know at how long it is going to take. And the judge may not be readily available to handle such a matter. So that is why recusal has to, very rarely is it allowed because it has cost implications, time.
All right.
Yeah.
As we close this conversation, Mr. Chintu, as a registrar, what should Ugandans understand about recusal as a tool of protecting fairness, integrity, and public confidence in courts?
I think the general public and the litigants should know that it is your right. If in case you feel that Judge so-and-so may be biased, maybe because I had he or she referring maybe in an interview to some issue, it is your right to still write to either the judge or to the principal judge or to notify the parties that you feel so-and-so should not handle this case. And it's a process, you'll be heard, and even the other side can object. And then the judge will also make a decision on that. But it is still your right to put in your request and the court will either grant it or deny it.
Okay. Thank you so much, Mr. Chintuziri Ntusa, who's the registrar with the Civil Division here in Kampala. And that brings us to the end of this conversation. One more conversation to go. Because of the conflict that is ongoing around Iran, courtesy of the United States with Israel, we have had about 40 plus students that have been repatriated from their back home. Their journey was quite long, but at least they've been repatriated. But there are many other Ugandans that have been affected. But by and large, it also affects our relationship with Iran. We do have Rashul Adid, who's having a sit down at the Iran embassy, and he's having a sit down with